Let me now introduce to you Christopher Patti, who is the attorney and university counsel for the University of California. California is the lead plaintiff in the Enron civil recovery suit, suing Enron on behalf of its employees whose pension funds were impacted in the Enron collapse.
Thank you. As Bob said, for the last 5 years, the UC Regents have served as the lead plaintiff in the Enron securities case. In that capacity, we've represented thousands of victims like Mr. Presswood and Mr. Brasier that you've heard here today, in attempting to gain compensation for the worst fraud in modern American corporate history. These gentlemen have explained, I think, much more eloquently than I can, the impact that the Enron fraud has had on the lives of individuals. But why did the University of California become involved? Well, the university holds pension and endowment funds. Those pension funds are the financial security for over 150,000 of our employees. The endowment funds support the university's educational mission. And those funds invested in United States securities depend on the continuing integrity of the U.S. securities markets. Our employees and our students were victimized, just like the gentleman you've heard here today. Our goal in prosecuting this case has been to hold the perpetrators accountable to the victims for two reasons, really. One is to gain the victims the compensation that justice demands. And secondly, to ensure that this sort of thing does not happen again in the future. So we embarked on a 5-year process of digging out the evidence. We retained fine lawyers who have worked very hard on this. And the evidence has shown that has seriously implicated Wall Street banks and the bankers who worked in them. The evidence has shown that these Wall Street banks worked hand in glove with Enron to perpetrate this scheme. The banks and Enron had a common goal: to mislead investors about Enron's financial situation. And they did that by engaging in transactions like complicated circular offsetting commodities trades that attempted to make simple loans to Enron look like something else. Or everybody's favorite, the phony purchase of Nigerian electricity barges that were unwound in 6 months, allowing Enron to claim phony profits on its quarterly statements. 4 weeks before trial, a United States Court of Appeals held that the banks were immune from liability to the victims. The court held that because the banks didn't say anything, they weren't responsible for their part in the fraud. On behalf of the Enron victims, the University of California Regents has asked the U.S. Supreme Court to reverse that decision and to hold that banks can be accountable to victims of fraud even when they don't make misstatements to the public. Essentially, what we are asking for is our day in court, the one thing the banks fear the most. Today, we are urging the Securities and Exchange Commission and the Department of Justice to support the position of the victims, as they have done in the past. We believe that they ought to fulfill the mandate of the Securities and Exchange Commission by supporting victims and not perpetrators of fraud, by supporting honest markets and not dishonest ones, and by supporting the long-term economic interests of the entire country rather than the short-term financial interests of a few Wall Street banks. We believe that the SEC should not abandon 60 years of its history and its own regulatory authority, which hold that perpetrators of a scheme to defraud can be liable to the victims. Thank you.